should they include? At-will employment, always, first and foremost, I will say. Florida is an at-will employment state. I know sometimes it doesn't seem like it, but so an at-will employment statement will say your employment's at will. There is no contract for any specific period of time. You can be fired or you can leave at any point in time with or without notice for any reason or no reason. And the reality is that's true, as long as it's not a discriminatory reason, okay? I don't include that, obviously you don't include that part. But full-time versus part-time, why do I say you should include this? Full-time versus part-time is not something that's dictated by law. It's something that's created by the employer, okay? So if you want to say full-time in your organization is 35 hours, then that's what it is. If you want to say it's 40 hours, then that's what it is. Now, when it comes to overtime and working over 40 hours, that's different. But here you're going to say, you might say, all full-time employees are entitled to pay time off of 1 week after a year. Well, what's full-time employee? You dictate that. Okay? They're your benefits. You dictate what's a full-time and what's a part-time employee. There is an exception to that. Of course, there's an exception to almost everything. Under the Affordable Care Act, when you're counting employees for purposes of health insurance, the ACA actually sets the number of hours. Introductory period, again, that's something, sometimes I think it's too heavily relied upon, but it's actually more narrow than you might think. The purpose of an introductory period is for unemployment compensation typically. It's now known as reemployment compensation. Most people still know it as unemployment compensation. But for there to be an introductory period, and the only thing it means, it's a max of 90 days. So you can't say you have a 120-day probationary period and have that fall under this. But if they are terminated within the introductory period and you have given them notice of the introductory period within 7 days of working, okay, and they are terminated for unsatisfactory performance, then any unemployment compensation that they get is not charged to your record. That's the purpose of an introductory period. And it needs to be in writing if you want to avail yourself of that.